Hi, hello, welcome to what is the third webinar in this series, collaboration between Kingsfield Academy and Freeths. I'm Carl Haynes, I'm a partner at Kingsfield Academy, and I'm joined here today by John Fotherby, who's my colleague and also a partner at Kingsfield Academy, and Alex Johnson, who's a partner at Freeths Legal Law Practice. Also in the background, you'll probably all be familiar, although you've never seen him, is Wayne, who's running the webinar for us. So thanks to Wayne, and he'll be helping us run the polls and channel through any questions which you might have during the course of this webinar. So as usual, this is going to be a 90 minute, where am I at? A 60-minute webinar. Hang on to your hats. It's only an hour, 60-minute webinar. We'll aim again to try and finish on the 50 minutes and have 10 minutes for questions at the end. It's always an endeavor. And during that, we'll have a few polls that we'll ask you to engage with. Just bring your attention to a few handouts and attachments we have for the webinar. We've got the previous questions and answers from webinar 1, and also from those questions that were asked in webinar 2, which we didn't manage to get around and address. They are also listed in the handouts. There's also the link there to the YouTube video, William Ury getting to yes. That is also in there, and we requested that you looked at that prior to this webinar, and let's hope that hopefully you have. And then, well, let's just do a quick recap, shall we? As I said, this is the third webinar in this series. The other two webinars are on our YouTube channel as well. So if you want to go back afterwards and catch up on what you might have missed, or just to recap what we've done, they're available on our YouTube channel. So in webinar 1, we looked at a case study situation and the impacts of COVID-19 on that, and the contractor's decision to the main contractor's decision to close down the site. And then webinar 2 started off on the framed by the client's letter to the contractor, and then how the contractor saw their position and what were the immediate actions they needed to do to try and get to grips with the chaos, shall we say? And we finished webinar 2 with the idea that, well, actually we need to collaborate and we need to get this to go somewhere other than dispute. And so that's the kind of outline for this webinar 3, really, is finding alternative solutions. And in just a moment, we're going to find out what that means. And John and Alex will continue their discussions on this case study. So in webinar 1, those of you that dialed in might have recalled we asked a question, and the results of that question was that 90% of the attendees said that they would be looking to collaborate with the owner on this. So so today is really about this discussion about what is needed to achieve this, or to achieve a collaborative settlement. So I think what I'd like to do first is I'd like to just see how many of you have managed to look at the first poll. Look at the first poll. How many of you looked at the William Ury video? So Wayne, if we bring up poll 1, let's just a simple question. Please indicate whether you managed to watch that or whether you haven't, and let's just have a look. So hopefully that won't take too long for those of you to just register that. Okie dokie, that's always a good sign. So so the video entitled "The Power of Listening" went down well. I'm not going to say you didn't listen. I'm not going to say that at all. But perhaps after this, you might want to go back and look at this. So okay, on the basis of those answers, then let me ask you another question. So Wayne, I'm going to get to move to the question on I want you to have a think now and tell us, how often do you participate in negotiations? Is that daily, weekly, monthly, rarely, or never? So just take not too long really to deliberate over this. Maybe the first thing that comes to mind, and Wayne, just as soon as we've got those answers up, maybe we can start that. Okay, all right, that's interesting. But I think I'm going to let John take a look at this. John, over to you. What do you make of these results?
Yeah, thanks, Carl. I think it's they're interesting results. Clearly, people are very much involved in negotiations, and it's what I would expect, because we're not just talking about, the question wasn't about commercial negotiations or contractual issues, about negotiating. And I think all of us are negotiating all the time. There has been some studies done, and it's been found that people probably spend more than 50% of their time a day in some form of negotiation, either with their families or with colleagues or with business acquaintances and so on. So negotiation is really a human issue, to be able to get things that we need and want. And if most things that we need and want, we require from other people, and therefore we have to communicate with them, and those communications are essentially negotiations. So that poll sort of confirms what we think. So the real question is, if as humans we are accomplished in our personal lives in dealing with negotiations for what we need, mainly individually, how do we translate that into applying the same principles of negotiation, the way that we deal with people, in a commercial, contractual business environment? For example, what sort of skills would we transfer across to the EPC contractor and the owner in our case scenario to try and solve the problem that we're looking at in that case? And I think the first thing, as soon as we move out the personal world into the business world and dealing with commercial, contractual, technical issues that we come across on projects, then we have to take a slightly different approach as to how we apply our skills. So Alex, I've got a couple of questions for you in that context. Let's think about the legal framework and some sort of do's and don'ts. And in the last webinar, you touched on these, but I think it's basically worth going back to them.
Yeah, thanks, John, and good afternoon, everybody. Thanks for joining us. So in terms of the legal framework for the negotiation meetings, they're effectively within what we could describe as a mini legal framework of their own. So in the last session, we suggested that a meeting of this type should be declared to be held without prejudice, or without prejudice save as to costs, and also subject to contract. So we introduced those three phrases. My recommendation was that it was important to ensure that that is documented, for example, in the minutes of the meeting, and that the minutes are signed by both parties as an accurate record. I think it's also sensible for the EPC contractor's meeting preparation that this is agreed in advance with the owner, and that a statement is made at the beginning of the meeting that confirms its status to everybody. So just a quick recap on those phrases. Without prejudice. Now, this is a type of legal privilege that protects genuine offers made to settle a dispute from being disclosed to a court or a tribunal. So that means that a court or tribunal shouldn't see documents that are marked without prejudice. And so it allows the parties freedom to speak openly in the meeting about resolving their problems. And without prejudice save as to costs is very similar, but this means that a court and tribunal can only see the documents for the purposes of assessing a costs award. So if you remember, under English law, the loser pays the winner's costs. And finally, subject to contract. That means that there's no binding agreement between the parties until they've reached a signed contract. So this protects the negotiations. And these phrases and this type of privilege will create an environment for both parties to express their views without the fear that what they say could be used against them. So you could see it as a protective wrapper for the meeting, and it's entirely necessary for a negotiation like this one.
So those are the legal concepts for preparing for negotiation and the protection in negotiation. But what about the contractual aspects, where the regulations for dealing with disputes, etc., are often set out in the contract? What's that look like?
Yeah, that's right. So we have a legal framework, which we've just addressed, and we also have a contractual framework, let's call it, which you're right, John, will be some form of tiered dispute resolution procedure that is set out in the EPC contract. And I'm sure we've all seen these procedures, and they differ, but generally they allow for tiers or layers of process that parties have to go through in the event that they have a dispute. So the first level might be meetings between principals, for example, at the project management level, perhaps escalating up to the board level even, before there's any escalation to a further, more formal process. Sometimes you see an option for mediation. Sometimes mediation is expressed to be mandatory, but it isn't always. In the UK, any construction contract, as defined by the law, the parties to that contract have a right to refer a dispute to adjudication at any time. Now, adjudication is a fast-track process that applies only to projects in the UK that are governed by the law, so it might not apply to our case scenario, given the suggestion that the country in which the project is being done is European, but perhaps not the UK. And then finally, most contracts, if not all contracts, will deal with the referral of disputes to some form of tribunal as a final resolution, and that's arbitration or court proceedings. You may have a dispute resolution board of some type. That depends on the form of contract, and there are certainly dispute boards within the FIDIC contracts. So in terms of the contractual chain of events and what's occurred, you could view the parties as being at the beginning of a conveyor belt towards an arbitration. Now, the conveyor belt was initiated by the owner sending the letter last time, threatening termination of the EPC contract. So following that, I'm sure that the EPC contractor will have submitted a claim notice and complied with any other requirements that he needed to comply with to protect his position. So these are also activities that are part of the conveyor belt, but they are necessary. A failure to comply with procedural steps can mean that a claim is time barred or that rights are waived. So it's very important in these situations that all of those steps, if they're in the contract, are followed. So the negotiation meeting is you could view that as a chance for the parties to pause the conveyor belt and hopefully turn the power off completely, because the end of the conveyor belt is probably going to be an arbitration in our case. Now, arbitration is a formal process of dispute resolution. It is expensive. Usually there is a single arbitrator or a panel of 3 arbitrators who the parties have to pay for. They also have to pay for the venue in which the hearings are held. So that's slightly different to court, where parties don't pay for the judge and they don't pay for the courtroom. Arbitration is confidential. It's not a matter of public record. Parties will have to pay lawyers, they'll have to pay expert witnesses, and they may even have to pay barristers to present the case. And it can take probably a minimum of 12 months to reach an arbitration award, but that's very optimistic, and often it can take a lot longer. So I suppose a question to pose ourselves here is, should we be taking the EPC contractor's case to arbitration in our case scenario? Why wouldn't we? Well, I think there are some very good arbitrators, and I think clients can get very good results from arbitration, but I don't think that's going to be the case here, even with the best arbitrator in the world. And the reason I say that is this situation is complex and it's unique. It's not a typical dispute where one party is at fault and the other isn't, or where one party is more at fault than the other one. Here, no one's really at fault because it's a neutral event. Money's not really at stake, or at least it's not an immediate concern. The immediate concerns that we've been discussing over the past 2 sessions are practical ones. When will the works commence? What measures are required when they do recommence? Can we recover the schedule? Those kind of issues are the ones we've been discussing. So I see COVID-19 as a neutral event. I haven't seen a contract that places the risk of a global pandemic on any one party. And that's not to say that there isn't one. And I'm sure that contracts drafted in early March may well contain something like that. You never know. So COVID-19 is probably a force majeure event. We discussed that in webinar number 1. If there's a causal link between the event and what's happening. So if the contractor's workforce is all sick with COVID-19, that's probably a force majeure event. So in my view, an arbitration over a force majeure event is pretty foolhardy. Force majeure is only about relief from a party's obligations. It's not about positive entitlements. So in many ways, these are sterile arguments. And given that the cost and the time investment for clients in arbitration is high, well, in my view, it really only makes sense when a lot's at stake and when someone is clearly right and someone is clearly wrong, or shades of grey more commonly. Arbitration isn't just about paying lawyers, arbitrators, experts. There's also the hidden costs. You know, disputes prevent people from doing their jobs. It diverts resource away from projects. There's a huge hidden cost of any big dispute like this one. So to the clients I've advised in relation to COVID-19 over the last few months, I've said the same thing. I've said I think you should try to reach an agreed solution with the other party, document it in a contract amendment or a separate agreement, because arbitration or litigation resulting from COVID-19 is probably going to have no winners. I think we should keep arbitration and litigation for the real disputes. For example, the courts in England were already busy enough before COVID-19. Imagine what would happen if every party commenced proceedings in construction projects for COVID-19 claims. How long would those claims take to reach trial? How much would that cost everybody? So the UK government has recognised this, and the Construction Leadership Council basically said the same thing, which the government has endorsed, which is parties should avoid conflicts over this issue. And they've even gone to the extent of drafting template letters for parties to send to each other to prompt the type of discussions and negotiations that we're talking about here. So there's a template letter: dear contractor, we don't think we should fight about this. We need to have a discussion. I'm paraphrasing. So there's no excuse in my view for a conflict in this case. So why would you make a bad situation even worse? So the conveyor belt in this case leads nowhere good. The contractual framework, I think, therefore, summarizing all of that, is that the parties need to find a resolution because the alternative is too big a risk for either of them to face. John, have you got any thoughts on that? And within that framework, how do you think the parties would get to the negotiation?
Well, first of all, I completely agree with you, Alex. I mean, this is a situation that is not worthy of taking to any arbitration or litigation. And in that context, the arbitrators, the adjudicators, the mediators, the judges in the court are human. And we're asking them to solve a problem that is completely unique, and there's no real parameters that are usually present for making those judgments or those awards, and therefore people will have to make up their own minds. And I mean, they're competent, experienced, highly qualified, but if you haven't got the framework against which to make the judgment, if you haven't got something to rely on, then it is really a source for appeal, because someone or both parties, one or both, may well be pretty dissatisfied with the outcome. So again, it's once you start the legal process, it's a continuing risk that you're going to spend even more money. And as you say, the money is not the issue in it. So we have to look at it pretty practically. What I'd like to do is just change the scene a little bit now, because it's a good question. How do you move from this sort of formalistic approach which you've outlined, which is perfectly suitable in many situations for dispute resolution, to a different one, and which is equally useful in any negotiation situation or dispute situation that needs to be settled? And I go back to the William Ury video, which didn't have a lot of take up, but never mind, I'm going to still talk about it. That William Ury is a pretty famous negotiator in all sorts of levels globally, and has been for a number of years, and is the author of a book called Getting to Yes. The video is about really listening, and Uri says, we were given 2 ears and 1 mouth for a very good reason. We should listen twice as much as we speak. And in negotiation, that's pretty good advice, I think. And in that video, he talks about an encounter with President Chavez, former President Chavez of Venezuela. And Uri's and his colleagues' task was to try and help find a solution between Chavez's government and the opposition in Venezuela at the time. And it was close to Christmas time, and he'd finished his tour, and he'd been talking to the opposition, he'd been talking to the government, and he arranged a meeting with Chavez, which was supposed to start at 6 p.m. and eventually kicked off at about midnight. And they entered the room expecting to meet Chavez and an advisor, and the entire cabinet was present. So the conversation started by the president saying, "Well, Uri, what's your thoughts on the situation?" And Uri basically said, "Well, I think things are improving and developing." And at that point, he'd only got about 4 words out, and Chavez jumped on him and said, "What nonsense are you talking?" and proceeded to go on and on about the opposition and how unreasonable they were. And Uri took a deep breath, because Chavez was famous for 7-hour speeches, and he thought he could be there till breakfast time. And then he has to listen to Chavez, who leaned across the table, more or less nose to nose with Uri, and went on basically attacking the opposition. And Uri says, "What could I do but listen? How would it have helped for me to challenge or get into an argument with the president of Venezuela?" And so it goes on for half an hour, and Uri's expecting quite a longer episode. But then he sees Chavez's shoulders shrink down, and he takes a breath and he says, "Well, Uri, what do you think?" And Uri says, "Those words were the sound of a human mind opening." And what he'd done was let Chavez basically have his say, make his point. It went on long, but then we get to a point where he says, "Okay, what do you think about this situation?" Those are the points that we're looking for in negotiation. Because if we have 2 parties who are very well set in their thinking about the dispute and what it's about, then there's a need for opening minds. And you can only get other people to basically change their behavior, which is what we're really looking for. If somebody's taking a certain position and it's not going to lead anywhere, then we need a change in behavior. And the number 1 rule for getting somebody to change their behavior is not to say to them, "Change your behavior," but you change your behavior first. That, in psychological terms, has an impact. And almost every time, the other party will change their behavior in response. So we have to start looking at how we actually behave in negotiations if we want to come closer together. Now, why is it important to get a mind change, and how is it that listening can actually do that? Well, with listening, you gather information. I'm pretty sure that in the Uri Chavez encounter, Uri was getting a lot of information. Whether it was good or not good, it's information. And in doing that, you're starting to see where the other party is. You're starting to observe things. They say things, they have body language, they convey information. And therefore you can use that information to understand where they're at. And that is the number one in any successful negotiation, is being able to get to understand where the other side is, and they want to know from you where you are as well. So there becomes an exchange. In negotiation, in this context, there are other little tricks to use. One is silence, which is also very akin to listening, and you're using both ears in that period of silence, and also breathing. Because if you're breathing well, you're putting oxygen into your brain, it slows you down and you can think clearly, and you're more receptive to hearing what the other side has to say. So this is why the whole thing about we've got 2 ears and 1 mouth for a reason. It really is about listening, so we get the messages from the other side and we can convey our messages to them. So if opening minds is a key to successful negotiation, then the question is how might we achieve this? How do we go about it? Because it doesn't happen by magic. Let's start by accepting for a minute that there are several phases to negotiation. And in our training programs, we basically see this as being 4 phases. First is preparation, which is about an internal activity in preparing for any negotiation before getting into engagement with the other party. In our experience, people in negotiations do not spend enough time preparing, and it's probably the most important stage. Then we have engagement, and that's when you're trying to find where the other side is, conveying to them where you are, and you're trying to discover what is a successful negotiation going to look like for both parties. And you explore issues. You're not talking, it's not good walking in and saying, right, we've got this delay situation, we want 6 months extension of time and £10 million. The other side are going to say, probably not, and therefore you've got nowhere. So you have to find a way to start engaging with them and start exploring possible areas of common interest. Once you've done that and you've started to understand where the other side is, then there's the time for exchanging. You start to negotiate then on the issues, but you have a wide set of subjects that allow you to maneuver those issues that you really want to get settled and find ways to do that. And then we have closure. And again, this is an area where often people walk away from the negotiating table and say, oh, deal done. And we find that there isn't one because there's a complete misunderstanding of what's been agreed. So we have to get things into writing, heads of agreement there and then, not 2 or 3 weeks later. And then you develop that, have an exchange, agree, then into formal agreements. But that isn't where closure ends. There is the follow-up to make sure that the things that have been agreed are enacted. Otherwise, they become totally useless. And therefore people see, oh, we've negotiated a deal, fine, shake hands, goodbye, and collapse of agreement. So given those 4 phases, and other people have different ideas, they might say there's 5 phases or 3 phases or whatever, you can structure it how you like, but you have to go through the process from preparation through to getting to something signed off that becomes a legally binding document. Wayne, I'd like to run a poll on those 4 negotiation phases with the question, where do you think there is the opportunity to open minds in those 4 phases? Preparation, engagement, exchange, or closure? I'd like the delegates to just express their view on that.
So, John, if I could just quickly jump in before you start to analyse these responses here. I just want to remind everybody that how to ask questions of John and Alex is down in your questions box. I can't see myself. Hopefully, I'm pointing in the right direction. Down here. Please type in your questions. I think we're going to have plenty of time to address these at the end. So as John continues with this webinar with Alex, please just type those in as they come up, and then we can deal with those in the last 10 minutes. Sorry about that, John. Straight over to you, please.
Not a problem, Carl. Thank you. I think that this is an interesting response. I basically agree with the delegates. I think that the greatest opportunity is in engagement and in the exchange phase. It's a continuation of that. But I would say that finding the levers that you need in those two phases is in the preparation stage, and it's absolutely vital, because these triggers to these levers to open minds are sometimes not obvious, and we have to think about those, of how we're going to do it. There's questions of culture, there's questions of the relationship as it exists. There's many things that influence how you're going to handle the other side in the negotiations. And the time to be exploring those is before you meet with them, so that you're actually aware and prepared as best as possible to try and anticipate what is likely to come. But as Field Marshal Moltke said, no plan survives contact with the enemy. So we can have a plan, but we need to be prepared to change it fairly quickly. But preparation, we cannot emphasize enough. Preparation for negotiation is absolutely key. So thinking about, first off in preparation, you really need to decide what style of negotiation do we want to have with this party. And there's really two styles that you can choose from. There's position-based or there's interest-based. Now, position-based negotiations are surface statements where an organization, a contractor, an owner, it doesn't matter, where it stands. And those style of negotiations rarely provide any insight into underlying motivations, values, or incentives. They are, this is my position, whether you like it or not, and this is where I stand. And there's a lot of negotiations that go on like that. And sometimes positional negotiation is necessary, depending on where you are in the whole process. But there's an alternative, and that's interest-based negotiating. And that's where you look at a party's underlying reasons, values, and motivations. Interests provide the opportunity to broaden the discussion in search of a settlement that holds value for both parties. We have to bear in mind that if we want a lasting agreement, both parties have to agree and be willing to agree and to be satisfied in that agreement. Otherwise, it won't last. The history shows that where you get agreements of one party that's been cajoled into a settlement will look for retribution later on to get his home back, basically. It's a human condition, you know, so we might as well try and get it right in the first place as have 2 or 3 goes at it. So if we think about interests and what I've just said, then that's a complete opposite with position-based negotiation. One is open, one is closed. So Wayne, I'd like another poll then for delegates to just think about that. Which style of negotiation is more likely to open minds? position-based or interest-based? How are we doing? Interest-based, obviously. No disagreement. It was quite clear. But I'm glad we're all on the same page about this. It's just nice confirmation. Let's move on then. If we're looking at interest-based negotiations, and the situation in the case scenario absolutely speaks volumes for this, and what Alex was talking about earlier, about it's a no blame situation. It's a no-brainer to try and find a solution that's interest-based, because both parties are going to be hurting. The question is how to mitigate that hurt as far as possible by some sort of collaborative solution where you can work together. So it's absolutely a no-brainer. But let's just talk about, I've said previously that preparation is fundamental, and I'd just like to run down some of the things that we would suggest you think about when preparing for a negotiation. It may seem obvious, but it's often overlooked, that you need to know your case and facts thoroughly, and engage with and gather input from the different sources in your own organization, because there's often a lot of information that's relevant to the negotiation process that people know about, that if you don't gather, you can be tripped up on. And therefore, it's first of all, talk to as many people as are relevant in your own organization to get their take and understanding on the situation. Number one rule. We would recommend doing a SWOT, strengths, weaknesses, opportunities, threats. It's a quick way to get a view on where you think you are in your case. And it's really necessary, because once you've done that SWOT, you may take a different view on life. After you've done that, then it's a question of determining what a successful negotiation outcome looks like from your perspective. What are your real needs and wants? What do you really want to achieve? Where are your interests? If this is interest-based negotiation, what are your interests? And knowing those early on shapes the way that you then further inquire into the preparation for the negotiation. If you've got those ideas of what successful negotiation looks like, then the next question is, what are the barriers to achieving those and identifying those? If you negotiate with yourself, you'll be successful. The problem is it doesn't produce very much. You have to negotiate with somebody else, and therefore they're likely to be a barrier to what you want. So understanding what those are likely to be, and finding out what the drivers are, understanding the drivers is really quite important. Ask the question, what stops us getting to yes? And that means learning as much as possible about the other side. Where do you believe they stand? What do you think their problem is? What are the things that are really inhibiting them? But there's a warning here. Don't believe your own propaganda about the other side. Try and find it on a fact-based mission, not a fairy story. Then comes the question, okay, we know where we think they are, we know what we want out of this, we think we know what a successful negotiation looks like. So we have to explore how we're going to engage. And that really means trying to find probable areas of common interest. And you need to start going into the negotiations geared with open questions for the other side, inquiring where they are to confirm your understanding, not closed questions, because closed questions take you nowhere and it doesn't get the other side talking. And going back to the URI video, we want to listen to them, not tell them. Then we need to start to explore the issues that might be valuable to the other side, but which don't cost you very much. Some things you may have in your power that really are not very, the cost is negligible, but is highly valuable to the other side. And equally, you need to determine what is really valuable to you that you can't afford to give away, because you wouldn't achieve your objective, you wouldn't satisfy your interests in the negotiations. And then you have to determine, okay, we go through all this. What happens if we can't reach a negotiated settlement? What are we going to do? Do we concede? Do we have a compromise? What do we do? Do we walk away? There are many, depending on the situation, you've probably got several options. Then it's really about negotiating, the negotiating team. Who's going to lead it? And the most important thing here is the person that's leading it is has got the power to settle. And it's very important for that person to ascertain with the other side that they've got a person that's leading their negotiations that has the authority to settle. And lastly, these sort of meetings, these sort of negotiations require rehearsing, because you spend time rehearsing the whole of what I've just talked about and you start to find the flaws in it. Do the facts stack up? Well, we found something different. What's the other side look like? Well, we thought it looked like this, but now it's something else. So you try out your whole negotiation plan, and then you've plugged the gaps where things are not working. And with that, you probably have a plan that can at least get you on the road to a successful negotiation. You will only know whether it's successful or not at the end when you've tried it. Yeah, you have to look for strategies, tactics to play, because the other side are not just going to say yes in the first 5 minutes. They will have their own requirements and their own interests, and we've got to find out what those are and whether we can marry them to ours. Do you have anything to add, Alex? How do you think the contractor should be, best approach the meeting?
My suggestion on this would be, and I agree with everything you just said, John. I think that's all really, really sensible. I think they should see this meeting as a mediation, but without the mediator. If anyone's familiar with mediation, it's a process where parties come together in the presence of an independent third party who's a mediator, and the mediator tries to bridge the gap between them, find a solution. And obviously in a negotiation meeting like this, we're not going to have a mediator, so someone has to be the mediator as well. And my suggestion to the contractor would be, yes, act in your own interests and try to get what you want from that meeting, but also act as the mediator. You know, be the grown-up in the room, rather like Uri did with Chavez. And in another of his videos, I think Uri has referred to this as the third side. You know, there's one party and there's another, but there's a third side, and who's going to be the third side? Now here we know that the owner is pretty upset, and so I think rather like Chavez, they probably want a chance just to vent their frustrations, because this contractor walked off the site, they closed it, they didn't tell anybody about it. You know, your project's getting more costly and delayed. They're going to be pretty annoyed and pretty upset. So I think the contractor just needs to go into this meeting quite humble in a way, show that it's listening, and let the owner have its say. If the owner wants to blow a gasket for half an hour, let them do it, you know. In a mediation, both parties have the chance to do that. The mediator will usually say, right, first party, set out your position. tell us about your views, and then they'll do the same to the other party. So everybody is together at the beginning of a mediation and views are exchanged. So the contractor can let the owner do that, or the contractor could even go first. But I think in this situation, it's best to let the owner have their say, and then the contractor can respond to it. And the contractor's response needs to carefully acknowledge the owner's issues, because the contractor is trying to find the area for discussion and possibly agreement in this situation. So both parties will have to move here. Mediation is always a compromise. It's not about winning and losing, it's about finding a settlement and agreement. So I think the contractor has to choose what to argue over. I don't suggest arguing over the facts, because they are what they are. You walked off the site, you can't undo that. Yeah. Mediators, they usually have a range of techniques that they use, but essentially there's two sides to it. They are facilitative, so they try to encourage a settlement. So the contractor should consider what might motivate the owner to find a settlement here. And sometimes that's just about analysing the potential for legal spend versus the risk of litigation. So how much might you spend compared to what you might lose? And that's a pretty powerful point, especially when disputes are of a lower value, but even when they're of a higher value as well. And the other side of what mediators do is evaluative. So they will evaluate issues to make the party see that there's another point of view. There is a third side here. For example, the contractor would be well advised to take some legal advice on the points that he thinks come up in the meeting, or may come up in the meeting, and whether those are his strengths or his weaknesses. And we're always very good at trying to support our strengths, but we often don't analyse what the flaws in our arguments might be, as John discussed earlier. So the contractor, I think, should be in a position where it's prepared to neutrally present those points of view in the way of, we're advised that the court is likely to decide this. Not, we think that our position is this. You're not trying to persuade the other party that you're right here, but what you're trying to do is create doubt about the strength of the other party's position by showing them there's another point of view that has some merit. So I reinforce what John said about listening entirely. I'm often struck by the fact in disputes that parties try to engage with what they think the other party's position is, not necessarily what it actually is. And so I think we need to be wary that we formulate our own views on another party's motivation, because we're very defensive in our correspondence and we're good at writing letters that protect our position, but our views are not always correct about that.
Right. I think I agree with that, and I think that it really is on the contractor's side to take that position and try and calm things down. It's in their real interests. They probably want to finish the job, and they've got to bring the owner around to a way of thinking that they are the party to do that, and therefore dispel any ideas of termination or swapping the contractor or whatever. But you've got an uphill struggle to start with, because there'll be a lack of confidence and trust. And therefore you run the risk of it, if you go in heavy-handed, you just both parties are further and further apart. There's no route to success by doing that. And setting out demands, there's almost a question of, how can we help you, dear owner? And how are we going to work this out? And I don't think there's any reason why they shouldn't explain their motives for pulling off the site. There may be some very good justified reasons. They may not have a contractual or legal base, but they may be emotional hooks that you can get the other side on, because you were dealing with looking after the people, etc., that we talked about in the last webinar.
Yeah, and I think sometimes as well, timing is everything. When do disputes settle? Before Christmas quite a lot, or when people come back from their summer holidays. There's a good time to catch these moments sometimes that can be to an advantage. So
guys, just quickly before we move into the questions, and we've got a couple of questions to come through. I wonder if, because it feels like, certainly, being sat here and having listened to you talk for 3 webinars now, we've covered a lot of ground here. So I think maybe if give you an opportunity both to, and maybe let's start with you, Alex, and then finish with John, whether you've got any kind of, concluding comments or reflections that you may have over these 3 webinars that, you can offer us here.
Yeah, I think there's no doubt that the pandemic has created a unique and unprecedented situation in terms of global engineering construction, and I've seen directly the effects that it's had on clients in terms of, whether you do the work, if you do the work, how do you do the work, what are the positions on force majeure, all of those kind of issues. So the case scenario that we set was based on some real life issues really that parties are facing. So as someone who deals with construction and engineering disputes every day, I see the arguments that parties make, and I see what they fight over, and I see what they win and I see what they lose. But it sort of almost goes against my grain to say that I encourage you not to fight over this issue. I actually don't want to litigate this problem for you, because I don't think anyone's going to win. I do say to clients at the moment, take the advice that you shouldn't fight over this, follow what the government is saying. That's all very sensible.
And you, John?
Well, I completely agree with Alex there. But from my perspective, I see this as an opportunity for industry to start doing things differently. We've seen different behaviours across society as a result of this. From an engineering construction point of view, when the medical problem is over, we will still be living with the consequences of this for a long time, from an industry point of view. And really, that means we need to accelerate getting rid of the contracting models that we've been using, which have not been highly successful for the last 20 years or so, and doing something differently. I see a real opportunity from this situation for people to be able to start and collaborate and to make do things far better, rather than just reverting back to where we were before COVID-19 sprang upon us. So that I see a positive coming out of this if people want to do it.
Great, thanks. By some planning or miracle, we've managed to arrive towards the end of these webinars with time to answer some questions. So you two will be relieved you don't have any homework to do this week. So
why are you surprised, Carl?
Habits. Okie dokie, right. So Alex, this first one's for you. This is from Juan Pablo. And this is regarding your comments about contracts containing an allocation of responsibility for COVID-19.
Yeah.
So Juan Pablo says, certainly in his experience, existing contracts do not contain anything about this. However, for some ongoing tenders, some clients are now requesting contractors to consider the impacts of COVID-19 on their tenders. So how reasonable is this? And what advice would you give to try not to assume an unreasonable level of risk on these tenders?
It's reasonable, first of all, and it's also a good question. And colleagues of mine that draft contracts, I don't draft as many contracts as I used to now, but I know that they are inserting clauses into contracts that are being tendered and signed at the moment to deal with COVID-19, simply because, as Juan Pablo has rightly pointed out, contracts don't specifically deal with it, or don't even really deal with it in general terms. And I think the position that most parties are reaching is that consideration has to be given in terms of extension of time entitlements to disruption and delay caused by COVID-19. It also has to be given to the fact that work cannot be done in the way that it was before COVID-19. So there are, in the UK, there's rules on social distancing on construction sites. There are rules on how many people may be in certain areas. All of those sort of things have to go into the contracts that we are now dealing with. And we have to accept that things won't be done as quickly as they used to, perhaps. And so, yes, you do need clauses that do that. I don't think it's right that contractors should be at financial risk for delay and disruption caused by COVID-19. And actually, I think from the owner community, there is an acknowledgement of that as well. because this is not an event that is punitive. It's not an event that someone should seek to profit from. And so I think the guidance is that it's effectively a force majeure event, and that's how it should be treated, but with specific drafting, rather than just leave it to how the contracts have always dealt or not dealt with it.
Mm-hmm.
Could I just add one point to that, Alex? And that is with an existing contract. And I'm dealing with one right now today, where for other reasons, there's an amendment to the contract to resolve some other issues, delays and cost issues. So there is an amendment that amends the contract in the full face of COVID-19 being present in the background. It's not affecting the job at the moment, and it hasn't affected the job directly. But the potential of it re-emerging is still fairly high. And therefore, and there's a force majeure clause, and a proper force majeure clause in the contract that would cover it were it not unforeseeable now. And therefore, I think in those situations, it's very similar to what you've just said, but parties signing amendments to contracts, not change orders or anything like that, but real amendments to change the contract to cater for situations, should be aware that unless there's some careful wording put in there, the force majeure provision may no longer be applicable in the event that there's a recurrence or a spike or whatever they're calling it in COVID-19.
That's absolutely right, and that's the reason for specifically amending contracts that you enter into now or recently, because you're absolutely right, John. The foreseeability argument destroys a force majeure position because it's not unexpected and it's not unforeseen, and therefore the part of the definition force majeure simply falls away. So that's absolutely right.
Okay, so quick one for you, John. I think it's a quick one. It's more of a statement from VCAS, actually. Statement worded as a question, I think. Welcome back, VCAS. So in negotiation, legal or arbitration is the last step before working out amicable solutions. This is the last recourse after all options are lost, correct?
I'm not sure. I think I would prefer to negotiate before I start to arbitrate and litigate. I think there's a big, and it goes back to what Alex was saying. What's the contractual structure in the contract for dealing with dispute resolution? And again, I'm dealing with one right now where the negotiations were going on. The parties were getting further apart rather than closer together. It got to a crunch point, and our client, as an owner, served a notice of dispute with the intention of continuing negotiations, which they did. It brought some sense of urgency to avoid the litigation, arbitration, whatever, and find a solution. So I think there's a tactical game plan that needs to be developed. It depends exactly on what Alex was talking about in what are the different levels of dispute resolution in the contract and how you can play those. And it also depends on the situation and the relationship between the parties and what they're really trying to get to. So one has to be careful. But I would be cautious before I start arbitration or litigation without having tried to find a negotiated settlement. You can negotiate and fail, start an arbitration because there is a dispute then, and you can always come back to negotiation. But if you don't try to negotiate first, you're creating the conveyor belt that Alex was talking about that will be very difficult to get off.
And it's not an either or, most cases still don't go to trial. And the reason they don't is because parties reach a settlement beforehand. So you don't have to arbitrate. And as John said, you may well be better off not arbitrating. But even if you are, you can always have a negotiation. The doorsteps of the court is where a lot of cases settle.
Yeah. Okay. I just want to give a kind of early apology because I think we've got two questions, and I think it'd be nice to deal with those as this is the last webinar. So we're going to go a few minutes over time, and I do hope that the people remaining in here will forgive me for that. So one other one from VCAS, and Alex, why don't you handle this one? So and this sounds like it's more of a strategy question. So does the contractor start with creating common grounds and agreements before moving on to the disagreements, and then find out the solutions and have win-win solutions? Is this approach appropriate to start with? So it sounds like, do you start by finding the common ground and then deal with the disagreements? It sounds like he's thinking about strategy order of things.
Yeah, that sounds like a good way around to do it. I think if the contractor goes in all guns blazing with what he wants out of this, that's going to look very bad. And there's a technique that I've heard referred to as the bad news sandwich, which is you encase the bad news in 2 sheets of bread which are good news. So, while something positive, we disagree with something negative, but nonetheless we something positive. So that's, tactically, that's a nice way of doing it, and I think you are more likely to get engagement doing it that way.
Yeah.
Okay.
I think, I just add to that. Sometimes the other issues disappear because you're actually identifying things that really need solving, rather than the things that are in conflict. They just become a part of the solution rather than the source of the problem.
Okay, so one final question from Mark, and I recognize Mark from before, so welcome back, Mark. John, to you, how do you, as the contractor, manage to be acting in both your own interest and as the third party without contradiction or undermining your interest through also being the third party?
Well, you're not being the third party, you're acting as if, and I think Alex used the word, be the grown up in the room. And it's exactly that. It's about being, this isn't about being, I don't want to use the wrong words, but soft. You have to be assertive. You have to recognize, as Alex said, your own position and not prejudice that. But a situation like this does really need an adult in the room to bring some sense, some calm, some objectivity, and to get the thing sorted. And if you've got a party on the other side that's irate and just wants to be polemic, then you've got to step back and say, okay, fine, we listen to all of that. And I think the reference back to Chavez was quite a good one. You let them have their blow and don't engage in it. And that's a sort of mediator type approach, is not getting involved in the battleground. It's trying to find a way around and find solutions. So I think it's perfectly possible for a contractor to take that adult role and act as if it was trying to be mediating the situation rather than just a straightforward haggling, which often happens and usually is worthless. Mm-hmm. So I hope that answers the question. It's not being a third party, it's acting as if you were, exhibiting similar behaviors and processes.
Okay, super.
Do you have any thoughts on that, Alex?
I think that's absolutely right. You're not being the mediator, you're acting the role of the mediator in addition to your own interests. And does thumping the table and screaming generally work? It doesn't. My 2-year-old daughter tries it, but she doesn't get anywhere a lot of the time. Well, within limits. I think an argument presented reasonably is much harder to contradict than one that is just about screaming and shouting.
Yeah, absolutely.
Okay. Well, okay. So that does bring us to the end. That's all the questions we've managed to get through, which is good. So. Well, chaps, I just want to say thank you to you for sticking this webinar series together for us. I have a feeling it's not going to be the last time we work together on webinars with Freeths. In fact, I know we're cooking something up. We have some ideas about those topics, but we'll also be guided by you people out there, that are dialing into this and calling into the webinar. Do we still dial in? Probably not. So let us know if there are any areas that you would like us to talk about. Either email that through to myself or to Alex or to John, and we'll take a look and we'll put this put a webinar together on it. Thank you for bearing with us. I know we've gone some minutes over time, but I think it was quite important to be able to draw this to a conclusion today. If you haven't managed to see the William Ury video, I would really commend that to you. It's quite an easy, short watch, and it's got some really good messages in there that I think you can take away and apply to your practice. As usual, a few days after this webinar, we'll have this up on our YouTube channel. So if you want to go back and look at any of the comments, or if you want to recommend it to any of your colleagues or friends, then please go ahead and do that. We would only be too pleased for more people to view those videos. Something I would like to say is that about, John's done he's raised some pointers about negotiation, so has Alex, about some behaviors needed to seek agreement. And we've touched on areas of negotiation, but this is a really small encounter with negotiation. If you really want some negotiation training, our courses last a number of days usually. So if this is of interest to you, then again, reach out to us and we can continue that discussion with you and see how we might be able to help. So that's the health warning out of the way. I can get rid of that one. What else? I alluded to the fact this has been 3 webinars. There's been lots of information covered on it. So John and Alex have agreed to put together a handy 10 key takeaways, or it might be 11 or 12, depends on how many key takeaways we can come to. But we're going to try and encapsulate these in a nice, easy takeaway handout for you. So if you have subscribed to one of our webinars, you'll be on our list and we will be getting this out to you. Even if you haven't managed to get onto live today, we'll have you from previous and we'll send that out to you. So, we hope you found this interesting. We hope we found this is useful, and I can see by the numbers that we've been getting that I think you have been finding it useful. We are Kingsfield, that is now, we're on a bit of a week off, so we won't be doing a webinar next week, but I'm reliably informed that on the 18th of June, we'll be doing our next webinar, which is about project triage. And we've talked about collaboration here, and that's underpinned by key behaviors. And, the behaviors that are essential to collaboration, and creating the spaces and the environment in which people can have these grown-up conversations that we've been talking about, and these open conversations. And so this is going to be our next webinar, and it will be have my colleagues Gabrielle Burian, Karen Cheryl, and we'll have a guest speaker in Mark Emden on there as well. So if that's of interest, keep looking out on our website, keep looking out on our LinkedIn page, and you'll find more information on how to register there. So I just want to say thank you again. Thank you to Wayne in the background as ever, and thank you all for joining, and I hope to see you again soon. Bye-bye.
Thanks very much. Bye, everybody.